Good afternoon, everyone, and thank you so much for joining our webinar today, Common COBRA Mistakes and How to Fix Them. My name is Christine, and I will be your moderator today. ERISA attorney Larry Grugin is our presenter. We have a lot of great content for you today. If you missed something, don't worry. We'll be emailing you a recording of the slides after the webinar concludes. I'll be keeping the webinar muted to avoid any background noise. We'll stop at the end for questions. Just type your question in the box below and I'll read it aloud for you. Before we get started, I wanted to introduce a few new features to our current COBRA offering. Our enhanced COBRA program improves the billing and payment experience while reducing labor-intensive manual processes for HR. It includes online enrollment, real-time access and updates, integrated full payment solutions, accurate and timely premium remittance, complete admin and accounting reports, easy data analytics, 24/7 employee portal, and an admin portal. We're very excited to present this to you today. If you have any questions, please feel free to type them in the question box, and I will be sure to connect you to a product specialist. Okay, Larry, I'll hand it off to you now. Take it away.
All right, thank you very much. What I'm going to try to do today is cover the common mistakes and errors that employers and administrators make in administering COBRA. There's a lot of nooks and crannies in COBRA, and it's very easy to make a mistake. Just because you make a mistake doesn't mean it's going to be horrific. But the best thing to do is try to catch mistakes as early as possible. There's some common ones that I will point out and how to try to alleviate those issues. So there's a number of areas I'm going to be covering. Some may not apply to you because you're larger. But again, I think it's important to understand some of the major points when you're dealing with COBRA administration. And the issue and problem with COBRA administration, and I found, and this what really is in the fear of many employers, if you do make a mistake and a person isn't given a COBRA notice or isn't provided COBRA, then what happens is an angry former employee will probably go to the DOL, and all of a sudden the DOL will contact you, and that may trigger an audit. So you got to be real careful. And because there are penalties, which I will indicate in there, if you don't offer COBRA to individuals. So this is something that many employers are sensitive about and making sure. And it's also very common, and this is something that happens quite frequently, that many employers, when someone terminates, they don't send a COBRA notice, but they don't take them off the plan. And that's an issue, especially for the insurer or for the stop loss carrier. If you have somebody on your plan, you're not offering COBRA, and they shouldn't be on your plan, and it doesn't become a large issue unless all of a sudden there's all kinds of claims involved and the insurance company is thinking twice about paying them. Another issue that comes in, especially, and this is very common, which I will go through in the next few minutes, is the fact that many times many employees get divorced. They don't tell you to take the spouse off the plan, and they don't tell you until way after they're supposed to. In this situation, as an employer, the employees have 60 days to inform you of a divorce, and if they don't inform you within that 60-day period, then you as an employer don't have to offer the spouse coverage. So the employee just made a horrible situation even worse by not notifying, and it's a responsibility both of the former spouse and the employee to notify. I mean, and as long, I think, as long as you have provided the proper notices, the employee should understand they have some responsibilities, which I will go over in the next few minutes. First of all, a very common situation, this is a common situation, especially with smaller employers, is the fact that the employer assumes that COBRA doesn't apply. So as you know, the threshold is you have to have 20 more employees in the previous calendar year. COBRA applies to private sector employers as well as state and local governments. The rule includes built-in exemption for those employers that have fewer than 20 employees. Now, one thing that's very important to understand when you look at this, we look at this as on a control group basis. And also, if your employer has employees overseas, those employees are also counted too. And again, if you have 20 employees in the previous calendar year. So generally, if you go to 20 in a year, the next year you have to offer COBRA. So again, employers may be aware of the exemption. You know, they're aware of the state mandates, state continuation, but they may be kind of fuzzy about when exactly COBRA does apply in this situation. So depending on circumstances, determining how many employees you have for COBRA purposes is complicated because you have to count each common law employee, and then a part-time employee is also counted, but on a fractional basis, depending how many hours they work. So again, you have to do this on a control group basis. So if you own other companies and they have employees, you have to total them up, and they may have different plans. It doesn't matter. To determine whether COBRA applies to you, all that is has to be looked into. So in general, COBRA will apply to employers that have 20 or more employees and more than 50% of the typical business days in the previous calendar year. So again, if that's true for 2018, then COBRA has to be offered at the beginning of 2019. So this means the calculation will apply for the entire calendar year, and it doesn't change if the number of employees go up or down. So again, it's dangerous not to assume you don't have to offer COBRA. You really have to double and triple that calculation to make sure. But again, as I indicated before, you count all employees, including full-time employees and part-time employees, but you don't include individuals that are not common law employees. For example, shareholders, S-corp shareholders, and partners are not counted in that situation. So a part-time employee counts as a fraction, divide the number of hours worked to be considered full-time. And so if normally it's 40 hours and they work 30, it's 3/4, they're counted as a 3/4 of an employee. But again, this is something you have to really carefully look at to see exactly. And also, if you go down, remember it's 20 more in the previous calendar year. So if you go down in numbers in a year, it's if you have 50 more in the previous calendar year. So therefore, COBRA may not apply for a couple of years. So you have to look at that, especially if you fluctuate. Now, another issue is assuming that COBRA doesn't apply to your plan or plans. Remember that once you determine that you are eligible that you are subject to COBRA, basically what COBRA does, it applies to all group health plans. What does that mean? Well, generally it applies to medical, dental, and vision. Now, it applies in those situations that are considered to be employer sponsored. What does that mean? It means it doesn't apply, and ERISA doesn't apply if you have voluntary benefits. So if you have dental programs or vision programs which are voluntary and there's no pre-tax employee contributions, then COBRA doesn't have to be offered. All right, so again, there's a voluntary benefit exception under ERISA, and if that benefit is not subject to ERISA, then COBRA doesn't apply. It's extremely important to understand that. But again, if the employer endorses, an endorsement means, for example, allows employees to make pre-tax employee contributions, that is seen as an endorsement. Other plans may come into play too, and I've had this discussion with many employers on whether their EAP, Employee Assistance Program, is a medical plan. And generally, if it provides, for example, counseling, either over the phone or in-person counseling, family counseling, psychological counseling, and those situations, then and that is provided by the EAP provider, and it doesn't matter that is embedded in your disability or life insurance policy. If they're providing medical services, that's considered a medical plan, and therefore you have to offer COBRA. Another situation is wellness programs. So if you have a very robust wellness program that includes medical testing and other medical services, you may have to offer COBRA in that situation. So again, review that with your broker, review that with your attorney to make sure you're offering COBRA to every benefit that you offer that could be subject to COBRA. It's extremely important. So assuming COBRA does apply, and again, examples of health plans that may be subject to COBRA. We're talking about medical, dental, vision, prescription drug and alcohol treatment programs, employee assistance programs, or wellness programs, and there's a caveat there, if it includes medical care, on-site health care, health FSAs and HRAs, and self-funded medical reimbursement plans are all in this situation could be subject to COBRA. And again, if you have just a referral type of employee assistance program where the program provides basic services under an employee assistance program, but doesn't involve providing counseling, just a referral, then that's not providing medical care, and COBRA doesn't have to be offered. So again, you have to look at the programs that you offer and see exactly when COBRA does apply. And this is a very common exercise, something you have to look at year after year to see exactly what your programs provide. In probably about half of the situations I've been involved with medical, with employee assistance programs, they do provide medical care. So again, be very careful in that regard. Now, another common question, what programs you don't have to offer COBRA? And here is a list: long-term care programs, accidental death and dismemberment, a group term life insurance, long-term and short-term disability programs, wellness programs or employee assistance programs that don't include medical care, exercise or fitness programs, and on-site first aid facilities. Now, depending, another issue, and this has become a big issue over the last 3 or 4 years, if you have, for example, programs where you offer medical care through the internet, you can see a doctor through that, and those situations, depending how it's structured, you may have to offer COBRA under those programs. So again, look at your programs and see what you have to do. Now, also too, another very common situation is when one of your divisions cancels its medical programs and thinks that, well, since I've canceled our medical program and we have people in COBRA, COBRA goes away. That's not necessarily the case. So as this slide indicates, another potential pitfall is to keep in mind is assuming that canceling or terminating a health plan means that COBRA obligations terminate as well. If an employer terminates one plan but continues to provide another group health plan, the obligation to provide COBRA continues. So again, if you own 3 companies and one terminates their plan, but the other 2 still have a medical program, then those individuals that are working for that company have to, on COBRA, have to be offered COBRA. So determining COBRA obligations in this type and situation can be especially complex. And I'll be talking about this in the next few minutes, where there's merger or acquisition situations when the buyer has to take in consideration, and they may have to offer COBRA to the seller's employees that weren't picked up by the buyer. And that's something all the time I check asset purchase agreements to see if there's anything in there about what to do in regard to those employees are not picked up. And that's something you basically have to look at. Also, too, forgetting about state law, many states enacted what's called mini COBRA or state continuation. And what's interesting, there are a few situations where state continuation may offer greater benefits. And now we're not going to go into state continuation, but I'm sitting in Illinois, and there is a few, in most situations in dealing with state continuation, federal COBRA offers more coverage. And also, many times state continuation just covers medical, it doesn't cover dental or vision. So that's another disadvantage. But there are a few situations, especially in Illinois, that I'm aware of, that state continuation offers more coverage. And the situation is, if in regard to spousal coverage, that spouse, if he or she's under over 55, they could have state continuation until they're 65, and that applies to both large and small employers. So you have to look at your state continuation and see if there's any situations at all that you have to give an employee a choice between federal COBRA and state COBRA, and many times employers don't do that. And and especially if you have a situation where you have an older husband and a younger wife, and the wife, the husband is 65 and terminates, and the wife is 55. Well, in Illinois, that spouse could get almost 10 years of continuation coverage. So this is something to look at, and don't ignore state law. Now, one of the most common mistakes everybody makes in administering COBRA, no matter how hard you try, is the fact that group health plans are required to provide qualified beneficiaries with specified notices explaining the COBRA rights, with very specified requirements as to what information must be included in the notices. Now remember, there's generally two notices that have to be provided. One is called a general notice, and the other is an election notice. A general notice is important because you provide it at the time they become eligible for the plan, and that general notice is extremely important because it outlines for the employee what happens if they have a qualifying event and when and how they're supposed to give notice. So that general notice is extremely important. And again, it's given at the same time you give generally the SPD to an employee. The second time is the election notice. And then the election notice is given when there's a qualifying event, that person qualifies for COBRA, and then you are basically indicating what they're entitled to. That's why it's called an election notice. And there are specifications about when these notices have to be provided. Now, as this slide indicates, there's a model general notice and a model election notice. You can use those, but I just want to warn you, it's not written for the faint of heart. It's very technical, and most employees try to read it, and it's so technical they have a hard time doing it. But if you use it, you're protected. Everything that you need to say in that is in the general notice, but I wish it was written in more layman's English. That's the problem. Now, a couple other notices that you have to provide, and this is extremely important to understand, is other notices are notice of unavailability of continuation coverage, and that notice has to be given to somebody who applies for COBRA and they're not eligible. And remember, in order to be eligible for COBRA, there has to be a loss of coverage and a qualifying event. If an employee drops their spouse and there's no divorce and there's no legal separation, and he or she just drops the spouse, well, there's a loss of coverage, but there's no qualifying event, and the spouse gets wind of it and applies to the employer for COBRA, well, you have to gently tell the employee and tell the spouse, I'm sorry, you're not entitled because of the fact that there's no qualifying event. Well, there may be in the near future, but in that situation, again, that person's not entitled to COBRA. Another notice that has to be given is notice of early termination of COBRA coverage. There could be a number of situations where where COBRA coverage is terminated early. One of the more common situations is the fact of non-payment of premium. Now, instead of notifying you that they have other coverage, they just may not pay the premium. But you still have to give a notice to that employee that their COBRA coverage is terminating early. You tell them it's terminating because of the fact that they didn't pay the premium. Now, one thing that many employers are wrestling with is that they have to check their, and from time to time, the government updates these notices. You have to make sure you have the most updated notice. So, but it's important to have procedures in place for keeping track of when and to whom notices are sent. Considering using a form of delivery that will provide documentation that the notice was delivered, such as a return receipt or other written proof of delivery. There's been a few situations I've been involved in where the employer or the third-party administrator just sent a general mail, and depending on the situation, depending on the evidence they have that they actually sent it, and the burden of proof is on the employer or the third-party administrator. So in the event that the qualified beneficiary asserts that he or she did not receive a required COBRA notice, these records can provide evidence of compliance. So again, it's recommended, not required, to, if you're going to mail it, do a return receipt or any other written proof of delivery. That makes it easier in case every once in a while it doesn't get to the intended person. So how do you correct situations if no COBRA notice was provided? And again, every once in a while, somebody slips through the cracks. So you have to send or resend a election notice. If no COBRA coverage was provided, consider, if depending on how late it is, consider offering retroactive coverage. And again, you have to have the cooperation of the insurer or the stop-loss carrier to do that. And if it's very late, you have to consider offering prospective coverage when the notice is very late. So again, check your records, make sure, but again, if no notice has been given, make sure you try to send it out as soon as possible. Now, there are penalties involved for not sending out. So an employer that discovers a failure to offer COBRA coverage should take immediate steps to correct it. An excise tax penalties for failure to comply with COBRA. Under ERISA, there's $110 per day statutory penalties for failure to provide certain notices, plus a possibility of extra contractual damages under COBRA's special other relief provisions. Lawsuits to compel coverage can create a liability of attorney's fees as well. Increased risk of adverse selection, incurring obligations in the future to qualified beneficiaries who would decline COBRA now. Impossible inability to terminate COBRA coverage even if the qualified beneficiary becomes covered. What I'm afraid of in this situation, if for some reason an employee is not given a COBRA notice, what I'm afraid of in that situation is not the penalties, but it may trigger an DOL audit. If a former employee complains to the DOL, they're under an obligation to investigate, and it may open up a whole can of worms. Because anytime I go into an employer, no matter how large or small you are, you're doing something incorrectly. Now, in most situations, the DOL will not penalize you, they'll just ask you to fix it, but the time involved of an audit, the expense of an audit in the sense of getting your attorney involved or your accountant or other employees involved to fix the situation can get rather costly. So I'm not worried about the penalties in this situation, and when I'm worried about the lost time and effort in trying to fix the situation once it's gone south. Now, another common mistake is failing to include the spouse and other qualified beneficiaries when sending required notices. So here, in certain circumstances, a COBRA notice must be not only be given to the employee, but also the spouse and any other qualified beneficiaries if you have evidence they don't live in the same address. And that's become more common ever since under ACA, children don't live with their parents because it's up to age 26 and parents still cover them. So a plan may generally satisfy the requirement to provide notices under COBRA to a qualified beneficiary and his or her spouse by furnishing a single notice addressed to both. It has to be addressed to both on the basis of the most recent information available to the plan. The two reside in the same location, so what you have to do is address it to both individuals. Similarly, there's typically no requirement to provide a separate notice to the dependent children who share a residence with the covered employee. But again, the situation is different and more common if the children are in their 20s, they're living apart from the parents, and they're still eligible for coverage. And that situation, just make sure that one notice to their parents may not be enough. You have to give it also, because remember, each qualified beneficiary has a separate election right. And if they're living separately, there's an obligation in that situation to make sure those qualified beneficiaries are receiving an election notice. So to minimize the possibility of errors involving notices, recipients, employees should be required and periodically reminded to notify the plan administrator promptly of a separation, divorce, or any other event in results that the spouse and or dependents no longer living at the same address. The plan should also have procedures in place to ensure that any changes in address are promptly and accurately recorded. And again, this is a very common mistake. Many employers don't want to tell the employer of a divorce, and they're slow in reporting it to the employer. So I mean, you have to be sure that if there's a divorce situation, there's a separation situation, you're informed of that and made sure, in case of especially the children, if they have a separate address, you have additional obligations to send additional notices. Another common situation is, and this happens a lot, the employer is responsible for notifying the plan administrator if in any event that the employer within 30 days of the following events. If there's a termination or reduction of hours of employment of a covered employee, most health plans have a requirement that if there's a reduction of hours and you have to work so many hours per week to be covered by the plan, if you go below that, then you may have to be terminated from the plan and offered COBRA. Now, there's an exception to that if you have a variable hour employee and that employee is under their stability period. Just because of the reduction of hours, it may not necessarily be a COBRA qualifying event. So only if the reduction of hours causes the loss of coverage is there a qualifying event, and this is extremely important to understand. Also, the death of a covered employee, also the death of a spouse. Sometimes employees don't notify them of a change of a situation. And also if a covered employee becomes entitled to Medicare. Now, one thing to remember about Medicare, just because you are entitled to Medicare and you sign up for Medicare, if your employer has 20 or more employees, that's not considered a qualifying event, because you cannot, if you become eligible for Medicare and you are a large employer, you cannot force them off the plan. So in most situations, becoming entitled to Medicare is not a qualifying event. The most common situation in this slide is a termination or reduction of hours, or somebody just terminates and for some reason COBRA is never offered, but they're never taken off the plan. So I've had situations where brokers call me where somebody's on the plan a year or two and they're never taken off. Another common situation where this comes in is workers' comp. Somebody's on workers' comp and the employer doesn't think that's a qualifying event because under workers' comp, it doesn't guarantee coverage. And in that situation, the only time that on workers' comp that coverage can be continued in a workers' comp if you're offered COBRA or family medical leave. So in that situation, coverage can only be continued in those situations. And it gets a little dicey if the employer doesn't realize that. The employee racks up a lot of bills and the insurer starts asking a lot of questions. So here, a reduction of hours occurs whenever there is a decrease in hours that a covered employee is required to work or actually works, such as absence of work from a disability or temporary layoff, but not including an absence due to family and medical leave, but only if the decrease is not accompanied by an immediate termination of employment. And again, I just want to warn you, if it's a variable hour employee, excuse me, it may not necessarily be a qualifying event. So if a group health plan measures eligibility for coverage by the number of hours worked in a given period of time, the employee covered under the plan fails to work a minimum number of hours. The failure to work at the minimum hours is a reduction of hours, and the covered employee's employment end is a qualifying event. And again, only if it incurs a loss of coverage. So there has to be two things that happen there. Now also too, what you must do, and the third bullet is extremely important too, note that the plan must have established procedures for how qualified beneficiaries can provide notice of divorce, legal separation, or child's loss of dependent status, including how and when notice should be given and what information should be included in the notice. Now, check your general notice that you give to the employees at the time of hire, because that information has to be in the general notice. And that's extremely important, because if you don't have clear instructions and the employees don't understand what their responsibility is, and if established procedures aren't in place, any notice, oral or written, given by the employee to any employee, their supervisor, could be deemed to be a notice of the qualifying event. So if you want specified procedures where you indicate you have to tell us this, this, and this, when you have to tell it and who you have to tell it to, check your general notice to make sure all that information is in the general notice. Another error is miscalculating the period of COBRA coverage. As this slide indicates, employers must offer employees and other qualified beneficiaries maximum period of COBRA coverage to which they're entitled. So you have to look at the qualifying event. It's either 18, 36, or 29 months and get it right. So the type of qualifying event determines the qualified beneficiaries are and the amount of time that the plan must offer health coverage them under COBRA, and double and triple check. And that information has to be, again, right in the election notice. So that's something you have to make sure that the proper period of time is reflected in the election notice given to the employees after the qualifying event. So as this says, in certain circumstances, a qualified beneficiary is entitled to 18 months, but may be entitled to a disability extension of 11 months for the total period of 29 months. And remember, in that situation, to get the extension of 11 months, that person has to be determined, to be disabled at the start of the COBRA period. And that determination has to be made by the Social Security Administration. And that determination by the Social Security Administration has to be provided by the end of the 18-month period. So your plan rules, as well as your election notice of any offer of 18-month period, should describe the notice required to either an instance of a qualifying event to request an extension of COBRA coverage. And again, that would be in the general notice. So telling the employee what they have to do to get that 11-month extension is going to be in your general COBRA notice. But keep in mind that certain events, such as failure to pay premiums, may justify termination of COBRA before the end of the COBRA period. And again, that has to be clearly indicated that any COBRA coverage is dependent on paying the premiums. Now also, and sometimes employers forget this, the special rules under Health FSA, and if a Health FSA is considered to be an accepted benefit, then under the Health FSA, you only have to offer COBRA to the end of the plan year. What does that mean? It means basically employer contributions are limited to $500 or a match. So if you just have employee contributions under your Health FSA, you have no employer contributions, then you don't have to offer COBRA for the full 18-month period or 36-month period. It's only to the end of the plan year. So again, as this states, the coverage period is only the end of the plan year, and the COBRA coverage does not have to be offered if the account is overspent. And what we look at in that situation, what is left over on the employee's account? And what's left over is less than what the COBRA premiums would be in that situation, then the employer doesn't have to offer coverage. So if the employee spent most of the money at the beginning of the year, the chances are the employer doesn't have to give them the opportunity to spend the rest at the end of the year. Another very common situation is charging the incorrect amount. So a health plan may charge COBRA qualified beneficiaries for the cost of providing COBRA coverage, and it may require qualified beneficiaries to pay up to 102% of the applicable premium for the plan. In the case of disability, can be up to 150%. So what is the applicable premium? The applicable premium is the cost that you charge the active employees plus 2%. So as this says, for insured plans, the applicable premium is equal to the insurance premium paid to the insurance carrier. However, the calculation can be more difficult for self-funded plans, but again, it's generally whatever you charge the active employees. Whatever that cost is, just add 2% of it, and that's the cost that you should provide to the COBRA participants. So the applicable premium is a total cost of the plan for providing coverage, so it includes both employer and employee portions. And I think this is a shock to the employees. They finally realize the true cost of health coverage when they see the COBRA premium. Many employers don't do a really good job of how much they pay, because most employers pay anywhere between 50 to 80% of the cost of the premium. And when the employee has to pay the entire 100%, it's a shock to them that the coverage is that expensive. Now also please remember, under the COBRA rules, the plan must calculate a COBRA applicable premium in advance for a 12-month determination period. The plan can choose any 12-month period to be a determination period, but must remain constant each year, and that COBRA premium cannot change during that determination period. So the COBRA premium may be changed for a new determination period if the applicable premium changes, and there are certain limited situations where the COBRA premium may be changed during the determination period. For example, if a qualified beneficiary changes coverage to another benefit coverage. So, but again, that has to stay the same. And so you as an employer pick the 12-month period with that COBRA premium, and many times it's reflective in and what your policy year or what your plan year is. So here, the plan administrator should use caution in calculating a COBRA premium. Fixing mistakes that result from overcharging, undercharging can be administrative burdensome, especially depending on the time involved in trying to collect the money from the employee from the former employee is a nightmare. So again, make sure you double and triple check those amounts. Now, in regard to ignoring incorrect premium payments, qualified beneficiaries may be required to pay the full premium for COBRA continuation coverage, even if the employer made the contribution prior to the loss of coverage, depending on what your policies are. A plan must allow premiums to be paid on a monthly basis. Now, what you have to do if somebody, and this happens every once in a while, what this slide indicates, it says if the amount of the premium payment to plan is wrong, but it's not significantly less, it's not something less than the amount due, the amount paid will be deemed to satisfy this requirement for the amount that must be paid unless the plan notifies the qualified beneficiary of the amount of the deficiency and grants a reasonable period of time, not less than 30 days, to pay the difference. So it's if the employee sends the wrong amount in and the employer never says anything, that's deemed to be a acceptance of the incorrect amount. So even if your plan does not send monthly premium notices, it must provide this notice of underpayment, or the amount submitted will be treated as full payment. And many employers forget that. So again, you have a responsibility of sending a notice saying, hey, you're short 10, 15, 20 bucks. Now, another thing that employers don't understand when you're dealing with COBRA, and this is highlighted on this slide, is the fact that once a qualified beneficiary is a COBRA participant, for all intents and purposes, they're treated as a active participant, which means they have the same rights. They can add coverages. They can add dependents. If they have a special enrollment event, in that situation, they can add dependent. In that situation, the dependent's not a qualified beneficiary. They don't have rights. But again, they could choose whatever benefits is offered to the employee. So a continuation coverage offered under COBRA must be identical to the coverage that is currently available to the plan to similarly situated individuals. Generally, this is the same coverage that a qualified beneficiary had immediately before the qualifying event. Now, at the next open enrollment or special enrollment, that employee can choose a different coverage and add coverages. So if they have a child and they're on COBRA, they could add the child and then switch to a PPO if they had an HMO. So qualified beneficiaries must receive the same benefits, choices, and services as similarly situated non-COBRA participants and beneficiaries. Any changes made to the plan terms that apply to similarly situated active employees and their families must also apply to qualified beneficiaries. And I get this question all the time, should I treat them the same? And the law is really clear. Terminating COBRA coverage too early. The continuation coverage offered under COBRA must be identical to the coverage that is currently available. Generally, this is the same coverage that the qualified beneficiary had immediately before. So again, qualified beneficiaries must receive the same benefits, choices, and services, and any changes made to the plan are similarly situated employees. Now, if continuation coverage is terminated early, the plan must provide each qualified beneficiary with an early termination notice, which I indicated before. So if for some reason it ends in a premium, you have to give them a notice indicating the fact that their coverage is ending early. So the notice must be given as soon as practicable after the decision is made and must describe the date of coverage will terminate, the reason for termination, and any rights that the qualified beneficiary may have under the plan or applicable law to elect alternative coverage. So again, they could actually appeal that situation. Now, one of the more complicated situation is understanding the relationship between Medicare and COBRA. And remember, in this situation, depending on when that person becomes enrolled in Medicare, depends on how it affects COBRA. And generally, if you enroll in Medicare before you're entitled to COBRA, then it doesn't, but just because you're on Medicare doesn't cut off your COBRA coverage. And one thing that many people, I think employees don't understand about COBRA, COBRA is not considered to be employer coverage. And if somebody's on Medicare, COBRA is going to be paying the insurance company of paying secondary. It's a very expensive program. So whether an employer or family member is covered by Medicare may affect the right of continuation coverage. So an employee's spouse or child who loses group coverage because an employee becomes entitled to Medicare may elect up to 36 months. So even though it's not a qualifying event to the employee, it is a qualifying event to the spouse and child, and it gets 36 months. So where a spouse or child already is receiving COBRA, due to the employer's termination or reduction of coverage, the employee is becoming entitled to Medicare may be a second qualifying event that will allow 18 months of a continuation coverage to be extended to 36 months, depending on the circumstance. If a employee first becomes entitled to Medicare benefits on or before the date of the COBRA qualifying event, the qualified beneficiary entitled to Medicare does not terminate continuation coverage. So it's before they elect COBRA, they become enrolled in Medicare, it doesn't cut it off. But if the qualified beneficiary first becomes entitled to Medicare after the date on which the COBRA continuation is elected, the plan may terminate the qualified beneficiary's COBRA coverage upon the date on which the employee becomes entitled, which means enrolled. All right. So a qualified beneficiary becomes entitled to Medicare upon the effective date of enrollment of either A or B. So just because you're entitled to Medicare doesn't cut off COBRA coverage. One thing I would suggest doing, and I come across this all the time, I was just reviewing the COBRA notices of a large employer, and their information was incorrect. It wasn't updated. There were changes to the COBRA notices about 3 or 4 years ago, and I'm surprised how many times employers failed to either provide all the information that is required or do not update their COBRA notice. So please make sure that the information is up to date and accurate. Also, make sure that when you put a rule in place that you follow it. So if you have notice procedures, you indicate you have to give a notice to a particular individual of your qualifying event. Don't make excuses or changes for other people, because in essence, what you're doing is you're changing your rules. So with respect to notice rules, plans should be reasonable procedures in place for covered employees and qualified beneficiaries to notify the plan administrator of certain events. Qualifying events such as divorce or legal separation of the covered employee under the plan. So again, that has to be specified in your summary plan description and your notices. Second, qualifying events, triggering events that occurred during the COBRA period should be again indicated in your notices. And you also basically have to inform them of the disability, the Social Security disability termination procedures. All that has to be indicated. So again, in order to be reasonable, procedures must be described in the SPD, specify the individual entity that should receive notice, Specify how the notice is be given either in writing or use a particular form. Describe the information required, such as if the qualified beneficiaries are involved, the date of the event, and then the nature of the event and the plan name and additional documentation that's required. Specify the timeline for giving notice, and provide for a proper handling of incomplete notice. In other words, you return any notice as incomplete. Another situation is that what's very common is that you have retired individuals and you have a retiree plan. And many times a retiree plan is a good deal. It may not be as a good deal as an active employee, but again, in that situation, if the offer of retiree coverage is different than active, that's a loss of coverage, and basically what you have to do is give a COBRA notice. If you don't give a COBRA notice at that time, then you have to provide COBRA at a later time. So again, if somebody terminates, they're offered retiree coverage, which is different terms than active coverage. That is considered a COBRA qualifying event, and you have to give a COBRA notice. So as this slide says, if no COBRA notice is given, then the COBRA notice must be given when the retiree coverage ends. So again, you can cut off liability by giving it at time of retirement. Asset sale. This is another very common situation where a buyer may have to offer COBRA coverage to the seller's employees. And that happens if the seller does not continue medical coverage after the sale. The buyer continues the business after the sale. And I don't know how many times the COBRA coverage is not even addressed in the sales agreement. If that's the case and the employer, the seller goes away and there are individuals that you don't pick up on the sale, they're terminated. It's not the seller's responsibility, it's the buyer's responsibility. So I don't know how many asset purchase agreements I've looked at and there's nothing about COBRA in there. So please be very careful when you buy a company. You could be buying a lot of liability, especially if, for example, you let half of the employees go upon the date of the sale and the seller goes away and there's no medical program that can provide it to them. Okay?
All right, Larry, so I'm actually going to go right into our last poll question before we answer a few questions. Are you satisfied with your COBRA solution? Yes or no? And then after this, we have 3 questions for you, Larry.
Okay, cool.
Suppose as we're collecting the responses, I could ask you the first one.
Mm-hmm.
Okay. So first question, if we have an employee who's retiring and is Medicare eligible when they retire, do we have to make an offer of COBRA for health?
Yes. Yes, you do. Because being entitled to Medicare is not the same thing as being enrolled in Medicare. Now, in that situation, if they are eligible for Medicare, I should say, pick COBRA coverage and then enroll in Medicare. In that situation, then as soon as they enroll in Medicare after electing COBRA, then that COBRA coverage would end.
Okay.
So please understand that. If they enroll in Medicare before the COBRA qualifying event, they can enroll in COBRA. All right, but the employee has to understand it's very expensive supplemental coverage because COBRA coverage is going to be secondary to Medicare. So they're paying a lot of money for secondary coverage.
Got it. Okay, thank you. The second question we have is, what happens if an employee didn't notify you he got a divorce last year, and they would like to keep their former spouse on the plan?
Ain't gonna happen. You can tell the employee, I'm sorry, but the spouse has to pound sand. You have a 60-day notice period. If you don't meet that 60-day notice period at the date of the qualifying event, which is the divorce, we as an employer don't have to offer COBRA to the spouse. So it's going to make a difficult situation even worse.
Got it. Okay. Next question. When someone elects COBRA, is there a requirement to automatically send a copy of the plan's SPD?
No. No. You already sent them a copy of the SPD when they enrolled.
Got it. And then I believe there was one more question. I cannot see it on my end anymore. So if I did not answer a question, please go ahead and type it now. And while you do that, I'm going to show our poll results. So that's great, guys. 92% of you are satisfied with your COBRA solution. Glad to hear it. Good. All right, let's see. Any other questions? That's all I can see on my end here. Oh, hold up. Okay. Does the employer have to remove the spouse?
When? That's an important question.
Divorce.
If yes, because the fact they're no longer a spouse upon divorce.
Okay.
Yeah, in that situation, remember your plan says you cover employees, spouse, and dependent children. And once the divorce happens, that individual is no longer a spouse, so they should be taken off the plan.
Okay, got it. Let's see here. Going back to the Medicare employee, if an employee is eligible for Medicare, enrolls in Medicare, and stays as a 40-hour week employee, this does not necessarily become COBRA eligible. Is that correct?
Well, there's no qualifying event because, in fact, just because if an employer that has over 20 employees, just because somebody enrolls in Medicare is not qualified, it doesn't cause them to lose coverage. Remember, there has to be two things. There has to be a loss of coverage and a qualifying event. And if you have more than 20 employees, all right, just because you become enrolled in Medicare doesn't affect your employer coverage.
Okay.
Now here's the, suppose you have an employee. He's an active employee. He becomes enrolled in Medicare and comes to you and says, on my own, I'm going to enroll in Medicare. I'm dropping coverage. That's my choice. In that situation, it becomes a COBRA qualifying event for the spouse and children, not for the employee, because enrollment in Medicare caused a loss of coverage. Even though it's voluntary, it's still considered to be a loss of coverage. Okay?
Okay. Oh, and this, okay, another question kind of going back to the previous one. There was an edit made. So if the employee hasn't informed you of their divorce and now it's been a few months, the spouse remained on the plan, how should I handle it?
Drop her as soon as possible, and don't offer a COBRA if the period of time that's elapsed is more than 60 days.
Okay, thank you.
You're not required. I should say you're not required to offer COBRA. And before you do offer COBRA, you have to talk to your insurer or your stop loss carrier because you're not required to do so.
Got it. Okay. Moving on to next question here. Let's see. Okay. If a current COBRA participant has family coverage, then becomes eligible for Medicare, would this be a second qualifying event?
Repeat the question over again.
Sure. If a current COBRA participant has family coverage, then becomes eligible for Medicare, would that be considered a second qualifying event?
I don't think so, but I'm not sure. I don't think so.
Okay. Another question we have, if we have an employee who is retiring, and forgive me if I already asked this one, we got tons of questions today, which is great. If we have an employee who is retiring and is Medicare eligible when they retire, do we have to make an offer of COBRA for?
Well, they have to be enrolled. They have to be enrolled in COBRA. If for example, if they, as I said before, if they are enrolled in Medicare and then there's COBRA qualifying event and they terminate employment, in that situation, they're entitled to Medicare.
Okay.
I mean, entitled to COBRA. I'm sorry. Now, if they enroll in COBRA and then enroll in Medicare, that will end their COBRA coverage once they enroll. Afterwards, if they enroll in Medicare.
Okay. Let's see here.
And I think what we're going to do in the future, we're going to have a program, a webinar just on Medicare and employers. We do this every so often. I think it's important because it's really complicated. And we'll have a program in the future just discussing how Medicare affects employers. Because COBRA is one, there's all kinds of other areas that affects it. So, you know, we can go in more detail in regard to this and do all the situations.
Yes, that's great. And so I just have one more question here I want to get to. Okay, so would the spouse be eligible for an additional 18 months of COBRA coverage?
When?
Let me see here. This could be a part of a past question. So you know what? I think we're ready to conclude.
Okay.
And maybe any other questions? We have your contact information on the next slide. And anyone can go ahead, email you, or call you directly.
Right.
What do you say, Larry?
All right. Take care, everybody.
Okay. Thank you so much. I really appreciate it. Have a good day.